welcome to Legal Action. My name is David Siegel. Thanks for joining us. Today we're going to be talking about Chapter 7 success, debt relief, how to get out of debt, helpful tips to stay out of debt. I want to welcome in my co-host, Jesse Barrientos. Jesse, welcome to the show.
Thank you, Dave.
Jesse, you handle bankruptcies, Chapter 7 and Chapter 13. What are you finding now? Is there an uptick in Chapter 7 bankruptcies under the current economic conditions?
Absolutely. People are looking for all different kinds of ways to get out of debt. A lot of people really don't want to do that, but what you find is that people have their back against the wall and they have no place else to turn, really. And it's very stressful emotionally, psychologically, even physiologically.
Yeah, well, it makes sense. We have 10% unemployment. We have housing which is not recovered. We have stocks that have not really recovered to the extent that they lost. So people are really hurting. The manufacturing jobs are leaving this country. I just see things getting worse in the upcoming years for bankruptcy and for people. Would you agree?
I agree, and there has to be some mechanism to give people relief that they need so that they can move on and kind of start over.
Right, and the mechanism has been there all along, and that's Chapter 7 bankruptcy under the federal bankruptcy laws, which provide a fresh start in certain situations when someone is not making a lot of money and when they do not have a lot of assets, or at least assets with equity.
Well, what about, is there a particular guideline, Dave, in terms of an amount of money that somebody can make before they can file?
Each state has a median depending on the family household size. So for one person right now, the median in Illinois is approximately $46,000. And for two people, it goes up a little bit from there. So if somebody is making less than that amount, then they technically qualify under the first prong of bankruptcy. The other prong is they must not have available money per month. Income minus expenses, there cannot be anything left. Otherwise, they don't qualify for Chapter 7 as well.
Well, let me ask you. Actually, I have a bunch of questions for you, but let me ask you this. What happens if they're a little bit over that standard guideline? And let's say maybe they're about $5,000 or $6,000 over that. Does that necessarily mean that they're not going to be able? Now, we'll talk about the other requirements that you have to meet, but just looking at that one, does that mean then necessarily that they won't be able to file a Chapter 7?
Well, not necessarily. The number I gave you involves the median income to qualify. If someone is over that median income, they still may qualify, but they have to pass what's called a means test. In other words, if someone has the means to pay back their debt, they're not going to be granted a Chapter 7 fresh start. But this means test is a mathematical calculation that has to do with a lot of different factors. In addition to your income, it has to do with what type of secured debt you have, whether you're paying on a mortgage, whether you're paying on a vehicle, what other expenses you might have. So it's very possible somebody could be over the median and still qualify for Chapter 7. Obviously, the closer to the median they are, the more likely they're going to pass. But in some cases, we've seen people way over, and because of their high secured debt, have qualified for Chapter 7 bankruptcy, which is the fresh start.
And when you say secure debt, just to make sure that the folks at home know what we're talking about, you mean debt that is secured with, like a mortgage or like a car, something that is secured with property, some type of collateral.
Right. Think of secured debt as this. If a person doesn't make the payment, there's something that could be taken back, whether it be a house, a vehicle, furniture, jewelry, electronics.
The kids.
There's something securing that payment. Now, kids are unsecured.
Okay, all right.
Which unsecured debt is debt that there is nothing they could take back. And that would be medical bills, personal loans, credit cards, utility bills, auto repossession deficiencies.
Let me ask, since we're just kind of briefly mentioned that subject, child support, it's really not secured. Does that mean that that's something that...
No, child support is something that cannot be eliminated in a bankruptcy.
Okay.
Absolutely, the court is looking out for the children. The federal government is looking out for the children. In fact, in a Chapter 13, they're paid at a higher priority than a lot of other debts. So child support is not only non-dischargeable, but quickly paid back under different chapters of the bankruptcy code. So it's funny you mention that.
Okay. Well, let me ask you about this. Let me ask you, let's say, because a lot of people have misconceptions about Chapter 7. I have a house, and I have some equity in my house, but I have a lot of unsecured debt. Am I going to possibly be, be available to do a Chapter 7 for me?
Well, we have to do a mathematical equation to determine how much equity is available for creditors. The state of Illinois allows an individual like yourself to protect up to $15,000 worth of equity in your home.
Now, what happens if, again, I own it with my wife?
She gets the exemption as well. So now the two of you can protect $30,000 worth of equity.
What if she's not filing for Chapter 7?
She's still factored in, not for her equity, for her exemption amount, but her 50% interest in the house, if it's jointly owned, she would have to be given credit for that. So it basically helps if she's on the property with you, even if she's not filing bankruptcy.
Okay. Now, what happens if say that I'm a little bit behind in my mortgage? Let's say I've missed a couple of payments and maybe the payments are a couple $1,000 a piece. So as I'm sitting in your office having a consultation, I may be 2 payments behind, so about $4,000 behind. Am I still going to be able to do that Chapter 7? Is that going to
You can
and
still
keep
do a
my
Chapter
house?
7, yes. You don't have to be current with your mortgage to do a Chapter 7. And in fact, if you do a Chapter 7, you've effectively eliminated your credit card debt, your medical bills, your personal loans. You're likely going to be able to catch up on the mortgage that you fell behind. But if you can't, and you can't catch up, and you find you're just not going to be able to make that payment, you have the ability to walk away from the house because you've technically eliminated the debt inside your Chapter 7. You'll just have to vacate once it's gone through a full foreclosure situation and gone to a sheriff's sale.
So if essentially what you're saying then is for me to be able to keep the house, I'm eventually going to have to catch up those 2 payments.
You're going to have to catch up if you want to keep the house under Chapter 7 bankruptcy laws. If you fall behind and you don't have the ability to make one lump sum payment to catch up, there is another chapter, Chapter 13, which will allow you to repay your mortgage arrears as well as making your regular mortgage payment once again over the next 3 to 5 years. So it really is a home saver, Chapter 13. But most people, if they're doing a Chapter 7, they're able to make that mortgage payment.
Okay.
They just have to get rid of all the stuff that they can't pay.
Sure. And I want to talk about Chapter 13 more in depth a little bit later as we go along here. What about my car? A lot of people feel that, hey, listen, I have this car and I really need to keep it because that's how I get to work. That's how I make my living. So am I going to be able to keep my car as well?
I can't see you getting on the 151 Sheridan Road taking a bus. I just can't picture that.
Can't see that, huh?
No, I can't see
Okay.
that. Yes, you will be able to keep your car. If it's a leased vehicle, you have to continue to make your leased auto payment. If it's a financed vehicle, you're going to have to catch up and make your regular payment on the car. Most people do not have a lot of equity in their car. In other words, they owe what it's worth,
Or usually they're upside down on it.
often upside down. So they just have to keep making their payments, and they're going to be able to keep their vehicle while they're eliminating their other debt.
Is the same true with the car as it is for the house? For example, if I'm behind on my payment, that's something I'm going to have to make up?
You are going to have to catch up. Most auto lenders do not want you to be paying in arrears. They want you to be current. Otherwise, they're going to repossess the car and sell it at auction.
Well, let me ask you about that. So let's say, I'm again, we'll say a couple months behind here on my car here, $700, and I really want to keep it, and we file Chapter 7 because they've called me and they said that they're going to send a couple folks out here to repossess the car, and we file the Chapter 7. Can they take my car still?
Couple things here. First of all, once you file the bankruptcy, an automatic stay is created, and that's a big roadblock that goes up prohibiting creditors from contacting you or taking property without court approval. The auto lender is going to want you to get current. They're going to afford you an opportunity to get current because they really don't want the vehicle back. They want your continued payments. If they determine that you can't get current, then they're going to repossess the vehicle, but it's probably not going to happen right away. They're going to offer you some type of arrangement to see if you can get current.
But they'll have to go through the bankruptcy court in order to lift the stay.
Right. They can go to the bankruptcy court and ask for permission to proceed against your collateral because you're not making payments. But they're also going to offer you a reaffirmation agreement, which is an agreement that allows you to keep the vehicle throughout the bankruptcy and beyond, putting you back on the hook for those payments, provided you can make timely payments and provided you have the vehicle insured.
Is it going to be the same payments, or am I going to save any money by doing this?
95% of the time, it's going to be the same contract payment that you had before you filed. In some cases, lenders will negotiate. Older vehicles, less value. They really don't want those vehicles back. They might be willing to cut the balance. But on a newer vehicle, you're most likely going to pay what you were paying before you filed the bankruptcy on the car.
Well, let's say, for example, in the rare case where my car's paid off, or it's just about paid off, and I have, I have maybe one more payment left, and I don't know, let's say maybe it's worth Blue Book, and you look at Kelly's Blue Book, and you've got 3 different kinds of values. You've got your
Pick the middle.
Private party value, trade-in, and such. So, well, let's say it's $3,500. Now, I mean, I have some equity in the value. Is the trustee going to take and sell my car to liquidate that money to pay the creditors?
Most likely not. As I told you about a certain dollar amount that the state of Illinois allows you to have equity in a house, you're allowed $2,400 worth of equity in a vehicle. But in addition to that, and this is important, each individual who files is afforded a $4,000 wild card exemption that they could sprinkle over any property. So you can use the $2,400 plus some of that $4,000 wild card and completely protect your car while getting out of debt.
Is that $2,400 per vehicle?
It's $2,400 for one vehicle.
Just one. So if I have
Just
two
one.
vehicles, I'm out of luck if it goes beyond those exemptions.
Right. In that case, you would use the $4,000 catch-all on the unprotected vehicle.
Okay. I just had a question. I want to slip back a little bit to the whole house thing with the exemptions that we have, $30,000. If my house was worth more than that and the equity, say, was maybe worth, $45,000, does that necessarily mean the trustee is going to sell my house?
Not
What do they
necessarily.
look at?
Well, they're going to look at what they can get for the house and pay the creditors once it's liquidated. So if someone's going to sell your house, they have to factor in the cost of sale, 5 or 6% to a realtor, closing costs, title fees. The trustee's going to look at what's going to be left.
So if a
once
couple
they sell.
$1,000s are left, probably he's not going to sell it.
Correct. It's not going to be worth the trustee's time to pay the creditors a small amount of money if that's all they're going to receive as a dividend.
Okay, and I just wanted to make sure that the folks at home kind of have enough, because that's certainly something I think that they'd be thinking about. Back to the car situation. If I do a bankruptcy, if I do a Chapter 7, okay, and am I still going to be able to purchase a vehicle? Am I still going to be able to have credit cards?
Yes. There is life after bankruptcy. You can qualify for a mortgage after 2 years. You can qualify for a vehicle loan immediately, or you can wait till the discharge, which takes about 120 days. You're going to pay a little bit of a higher interest rate, but you are going to be able to get an auto loan. Credit card offers will come as well, but they're bad deals, they're high interest rates, they're annual fees. I would recommend a debit card where you're taking the money out of your own checking account, but you have the Visa and the MasterCard logo for convenience.
Sure.
Or you get a secured card where you put a certain dollar amount in a bank account, and that is your charging privileges, which can sometimes be extended once you show that you make your payments on time. So there is life after bankruptcy, and usually a much better life than what you're in when you're in debt.
In fact, Dave, you've authored a book, The Complete Guide to Surviving Personal Bankruptcy.
Yeah, Chapter 7 Success is a book I wrote, and it's all about the knowledge that one needs to qualify and go through the process. Not so they can do it themselves, because this is not something they want to do by themselves. You want to do it through a qualified attorney, someone who handles bankruptcy on a day-to-day basis, but it makes them feel more comfortable about the process because bankruptcy has such a negative stigma to it, especially in the past, not so much now, but people are still fearful of bankruptcy. They think they won't be able to live anywhere, they won't be able to get a car, they're never going to get a job. These are things that the book lays out in detailed terms so they feel more comfortable.
Sure. Sometimes people ask me too, is my employer going to know that I filed a bankruptcy?
The only time an employer would have to know that you filed a Chapter 7 is if the garnishment was on your wages and your attorney had to send something to your employer to stop it. So typically the employer is not going to know, your neighbor's not going to know unless they go down to the courthouse. You're going to be protected. Your privacy is going to be protected for the most part. You're not going to be wearing a big B on your forehead.
Not a scarlet letter?
It's not a scarlet letter that you file for bankruptcy.
Okay.
It's relief, and it's afforded by the federal government.
Well, Dave, let's say, I'm really fond of this credit card that I have, and
Which one?
I had it since let's say Discover, or Visa, or American, either one of those. And let's just say, I've had it, since I was in I was going to say high school, since I was in college, and I've had it all this time. And I really don't want to include it on my bankruptcy.
Right. Maybe it's the first card you were ever offered,
Right.
and you have an affinity to it and a loyalty to it. Here's what I would tell you. If you have a debt on that card, even if it's $20, it must be listed on your bankruptcy schedules. You're going to lose that card. If you don't have a balance on it, if it's at a zero, then technically you don't have to list it because it's not a debt. However, be aware that most creditors subscribe to a service that notifies them of bankruptcy filings, and you're most likely going to get terminated anyway. So you might as well list it, and don't plan on keeping a credit card beyond the bankruptcy filing.
Okay, wow. How about, since we're talking about all those things, it's important for people to know, because those are some of the questions that I get as well. People ask a lot of times about student loans and about taxes and those kinds of things. We've already talked about child support, and I think maintenance, formerly called alimony, would also fall into the same thing that you talked about, child support, earlier. But what about student loans and taxes? And parking fines for that matter, or speeding tickets, or those kinds of
Sure.
things.
What you're mentioning are basically non-dischargeable debts, debts that are not eliminated in a Chapter 7 bankruptcy. Student loans are definitely not eliminated unless there's an extreme hardship, and that has to be petitioned in the court through an adversary. That would be someone who, when they took out the loan, were okay, but now subsequently they don't have the ability to work. Maybe they become disabled.
Okay.
Maybe they have an illness. There has to be some reason why they cannot pay back this loan. It's a difficult process to get that approved, seldom seen. So plan on a student loan sticking around.
Okay.
Same thing with taxes if they're recent. A tax has to be more than 3 years old, and there's a couple other requirements. But basically, a recent tax is going to be still due and owing. An older tax, more than 3 years old, possibly can be eliminated.
Well, what about, would the same thing apply to, for example, the taxes on my real estate?
No, real estate taxes run with the property. So if you're going to keep the property, you have to maintain those real estate taxes. If you're going to walk away from the property, you're not going to be responsible for the real estate taxes. That's going to be for the next owner or for the bank.
Okay, well, let me ask you a couple of questions, because we talked pretty much about Chapter 7, but I have some ideas. Same kind of scenario, but different chapter bankruptcy. You mentioned before in a Chapter 7 with the house, I can't have too much equity, and if there's money that I have owing and I want to keep the house, I'm going to have to pay that back, and I'm going to have to do all those other different kinds of things. And if I don't have a balance between my allowable expenses and my income, that is to say, if I have a balance left, then I'm not going to be able to do a Chapter 7. Or if I make over a certain amount that they allow, I presume that I have to pay my creditors back, which would mean I couldn't do a Chapter 7 anyway, right?
Right.
So what happens then when, hey, maybe I'm $20,000 behind in my house payment and the sheriff's sale is knocking at the door?
Well, in that case, if you're trying to save your home, Chapter 13 would be the best bet, because Chapter 13 basically takes the amount that you've fallen behind on your home, as well as the total amount to pay off your vehicle and any other debt that you have, and it lumps it all into one payment. Picture a big pot in the middle of this table. We're going to put in that $20,000 mortgage arrears in the pot.
Okay.
The total amount to pay off your finance vehicle, say $10,000 in the pot.
So if it's a car that I own and I haven't, it's not a lease car, it goes in the pot too.
Right. If it's finance, it's going in the
And
pot.
I don't have to make the monthly payments on it.
Correct. It's going to be part of this bill consolidation payment that I'm talking about, where you're going to pay a trustee a certain dollar amount per month based on your income minus your expenses. You're going to pay that for the next 36 to 60 months.
What about my my unsecured debt? What about the credit cards? I mean, the reason why I have to do this and I'm behind is because the arm kicked in and all of a sudden my mortgage went from $1,500 up to $3,500.
Right. Well, you're going to have to make the regular mortgage payment on your own again outside of the bankruptcy. The bankruptcy payment to the trustee consolidates the arrearage, your auto financing, and all of your other debt. So it essentially gives you 3 to 5 years to pay off what you couldn't pay on time. But you do have to make your regular mortgage payment again. That's a requirement. And you need to do this consistently to have a successful Chapter 13 to save your home.
Well, what happens if during that time I'm not able, for example, I miss a payment that I'm supposed to make on on my mortgage?
Well,
Can we roll that back in there? Can we modify it? What can we do?
Typically not. It would be a post-petition debt. But here's what you can do. You can try and petition the court, if you fall behind with the Chapter 13 trustee, to move that payment to the back or to reorganize the payment to make it work. As far as the mortgage that you fell behind on post-petition, the mortgage company might give you a repayment plan within the bankruptcy, so to speak, where they give you a few months to catch up on the month or two that you fell behind. So you almost get another lease on life, another bite at the apple. But once you start missing those payments, your case is either going to be dismissed or that mortgage creditor is going to ask for permission to avoid the bankruptcy and be able to proceed with the foreclosure because you haven't made your payments on time to the mortgage or you haven't made your payments on time to the Chapter 13.
Is there any way, for example, let's say my situation changes and now I'm not making enough to fund the plan, or my wife's situation changes and she's not making enough. And I think that's probably interesting to note too. In Chapter 13 or even in Chapter 7, do you, even if just one person's filing, do you take into consideration just my income and just my expenses, or is it the whole family, or is it, how do you?
When you're married, the court looks at the total family budget. So your non-filing spouse is still going to be a factor in determining whether or not you qualify.
So if she's making $100,000 and
If your wife is a tremendous breadwinner, that might prohibit you from filing a Chapter 7 because the court says she can help you with your debts.
what if she is just my fiance or my girlfriend?
If you're not married to her, then her income should not be a factor.
Even though we're living together.
If you're splitting expenses, that could be a situation. But if you're not splitting expenses, she's just living with you and she's making $100,000 a year, her income is not a factor. She's a separate entity, a separate economic entity.
Okay.
Because you're not married.
So-
And that makes sense, right?
It does.
Why should she pay for your debts if you're not married? So,
That's true. Well, why should she pay for my debts if I am married? That's what I was trying to
well,
figure
you have
out,
to
too.
talk to your legislature about that.
I guess so.
It's federal law.
Let me ask you, if, again, assuming the situation's changed, can we convert a Chapter 13 to a Chapter 7? Let's say, hey, I just can't afford, Dave, to make these payments anymore. As much as I want to keep the house and everything else, I just can't. So if we're maybe a year and a half, or even 2 years into a 5-year plan, am I going to be able to switch it to?
Sure. Circumstances come up. If you lose your job and you don't have that income, or if you have an illness and you fall behind, you do have the ability to convert to Chapter 7, provided you qualify for Chapter 7 anyway. So you must not have filed a Chapter 7 within 8 years, and you must follow some requirements under the code. But you do have the ability to give up your house at that point or give up the vehicle, convert to Chapter 7, and get a liquidation fresh start. You know, you gave it a college try. You tried to save everything through Chapter 13. It worked for a little while. It didn't work anymore. You want a fresh start. You do have the ability to liquidate under Chapter 7, yes.
How about the other way? Let's say more of a happy situation. Let's say, hey, we're in a Chapter 7 here, and we're struggling, and all of a sudden, hey, you know what? That job came through, and now I'm making more money. Not enough to pay everything off, in a lump sum here, but enough to be able to pay certainly for the secured debt that I have, and something on the unsecured.
You can ask for permission to change a Chapter 7 to a Chapter 13. Typically, though, you wouldn't be doing that on your own volition. The U.S. Trustee's Office, the Chapter 7 trustee, would basically be coming in and telling the court that you have the ability to reorganize under Chapter 13, you make too much money, you have too much of a surplus, and that they're going to petition the court to have your case either dismissed or give you the option of converting to Chapter 13. So it's almost not a voluntary thing, almost never. It's usually the pressure from the U.S. Trustee's Office, who oversees all the bankruptcy procedures, telling you or your client that you either need to convert to Chapter 13 or they're going to bring a motion to dismiss the case for abuse.
Because why would I want to? Why wouldn't I just want to get everything discharged, right? I mean, that's the idea. So that's why I wouldn't want to convert it from a 7 to a 13.
Right. Well, this is why you need to see an attorney who handles Chapter 7 and Chapter 13 bankruptcy, because they're going to meet with you, interview you, look at your income, your expenses, your assets, your liabilities, and they're going to lay it out for you as to what the court will likely do. So you don't want to do a Chapter 7 if you have surplus income, because the court's going to throw it out. You also don't want to do a Chapter 13 if you really don't have the ability to reorganize, because then you're just wasting everybody's time. If there's not funds to make the payments, it's going to blow up and blow up quickly.
Well, let me ask you this. I know a few years ago here they've changed the laws a little bit, and I get a lot of people who sometimes they don't even want to complete the forms. We'll talk about that in a moment if we have the time.
Intake forms you're talking about.
Intake forms, right. Because the voluntary petition for bankruptcy, Chapter 7 or 13, is extensive and it requires a lot of information. But are there any other hoops that I have to jump through? I mean, are there any other requirements? I mean, is it I just go into your office and complete the forms, sign it, you file it, and we rock and roll a little bit?
No, there's a few requirements that one has to do. First of all, a credit counseling session has to be taken before a case can be filed. And that's a 1-hour session with a credit counselor where you basically tell that credit counselor about your income, your expenses, your assets and liabilities, and they run you through a few scenarios and give you a few options before you're eligible to file a bankruptcy. That's the first requirement.
So it's like my credit psychologist.
Basically, you're in therapy, yes, and you get a certificate. It's the government, again, giving you a certificate that you're eligible to do something.
Fantastic. Okay, are there any other? So I have to do that before you can file it.
You have to do that before you can file.
If I file and I haven't done that, what's going to happen?
Your case is going to be dismissed like it never even happened.
Even if I take the class after I file it?
Most judges will not allow that except for some exigent circumstances, but typically if you don't have the credit counseling done and you file your case, you've done so in error.
Okay. What is the other hoop?
The other big hoop is that you need to provide 2 months' worth of pay advices or paycheck stubs or proof of your income so that the court and the trustee can look and see that what you put on your schedules under oath really matches what you're making to make sure you qualify. So that's important.
All right. How about after we finish things up here? Now we're ready to I've supplied all of my documentation, my taxes, my payment advices. And
Case gets filed is what you're saying.
Case gets filed, right? We
You
have
need to
a
take
meeting?
You need to take a 2-hour financial management class prior to your case being discharged, where you're going to learn
I have to
about
take another class?
another class. Yes, because you obviously didn't understand or weren't grasping all that you needed to grasp on personal finance. So the government wants to make sure that you don't file bankruptcy again. They're doing it for you so you understand about credit, about debt, living within your means, and also some good sources to go to if you're having problems, like the Federal Trade Commission, things like that.
Well, Dave, you are an accredited provider of the credit counseling.
Yes, I do teach the
Is that
2-hour
true?
financial management class. I am an accredited financial counselor, and that is something that's part of my practice. So all of my clients receive that as a courtesy. They take the 2-hour class through me.
Well, if I need therapy, Dave, I'll come and see you.
And if I need therapy, I'll come see you.
Absolutely. Let me ask.
We can help each other
We can
out.
help you. I think so.
I think so.
You know, it's important too because a lot of times people come in and they don't want to complete the intake form, and that's true whether or not you come and see you, me, or anybody else. And it's extensive and it requires a lot of information. It's better if you get a copy of it or ask for a copy to get it faxed to you, emailed to you before you come on in. But it's important, and people need to know. I can't divine what your situation is. I had somebody come in and they didn't put their income down, and the person told me, well, I don't know what it is. And I said, well, you're in a better position, sir, to be able to guesstimate or do whatever with respect to your income than I am. I can't pick something out of the air. And so it's important for you to be prepared. And, I understand it's a lengthy form, but this is the first step of the rest of your life. If you're going to be able to qualify for one or the other, this is an important step for you to take to be able to get out of the situation you're in. And it's going to require you to complete that form. So, complete it. Don't complain about it. If you have questions, very often other attorneys will have help for you to complete the form. And
Right. It realistically could take anywhere from 10 to 20 minutes to fill out the form. But you need that information as attorney to be able to determine whether or not they qualify for which chapter, whether or not bankruptcy is even a good idea. And then you also have to point out certain things as you're going through their questionnaire.
Sure.
For example, once they write down they have a student loan, you're going to want to tell them right off the bat that that is not something that's going to go away. So it's actually helping you advise them, and it's helping them to understand which chapter is appropriate. So definitely fill out the forms, give all the information to your attorney, and be honest. Don't neglect to tell the attorney that you have a piece of land in Wisconsin worth $50,000, because they will find out about it.
Sometimes they do that at the end of the consultation, Dave, after you've gone through everything.
Right. Well, that's when you switch them from a Chapter 7 possibility to possibly a Chapter 13.
Unless they want to get rid of the property.
And Jesse, what's the total process for, real quickly, on start to finish for a Chapter 7 bankruptcy?
I'd say on the longer side of 45-ish, wouldn't you say, Dave, something like that?
Yeah, sounds good. And a lot of the information is available in Chapter 7 Success, which is available free through a consultation. My name is David Siegel. Thanks for joining us on Legal Action, which we covered bankruptcy in Chapter 7. We'll see you next time. Dave Siegel alongside Jesse Barrientos. Thank you, Jesse.